right, welcome back. I think we've got maybe a few new people who were not here this morning, so just for your benefit, I have Judge Tom Greenholtz from Hamilton County, Judge Kyle Hickson from Knox County, and I'm Judge Jill Ayers from Montgomery County. And we are so pleased to be here to hear our last case on our October docket today, holding court at LMU. Each side has 20 minutes. If appellant wants to reserve rebuttal time, let us know. And any preliminary matters?
No, Your Honor.
All right, if you'll call our last case, please.
State of Tennessee versus Amir Spears.
Good afternoon. Joshua Hedrick for the appellant, Amir Spears. May I reserve 2 minutes of my time for rebuttal argument, Your Honor? And may it please the court, Amir Spears' conviction should be reversed for 4 reasons. First, that the state's failure to inform the defense of the circumstances of the identification process was a Brady violation. Second, and somewhat alternatively, counsel was ineffective in failing to engage an eyewitness identification expert. Third, that counsel was ineffective in failing to adequately challenge the claim that Mr. Spears had managed to get in the back seat of a Chrysler Sebring with a rifle in his pants without anyone noticing. And fourth, that the evidence was insufficient as a matter of law. First, Your Honor, I'd like to talk about the process by which the identification was made in this case. So, in this case, there were 2 individuals, DeAndre Woods and Hunain Rashid, and Mr. Woods and Mr. Rashid were at a house on Western Avenue here in Knoxville. A man named Elijah Bowman texted the 2 men and asked to buy some marijuana. And they arranged a sale of marijuana. And sometime later, there was a knock on the door of this house. Mr. Rashid opened the door and let in Mr. Bowman, who had texted about buying marijuana, as well as a fellow, DJ Wright. And those 2 men came into the house. And immediately after they came into the house, a 3rd man appeared at the door, and he was holding an AR-style rifle. And when he appears at the door, Mr. Bowman and Mr. Wright open fire with pistols. There is a brief exchange of gunfire. Mr. Bowman and Mr. Wright take a backpack containing $25,000 in cash, some marijuana, and a separate different AR-style rifle that was stolen. So when we get to, when the law enforcement responds, Mr. Rashid is unable to identify the man who was brandishing the rifle. He simply says, I have nothing, I can't help you.
He was in the hospital at that point?
He was.
Okay.
He was. And essentially, as I understand the transcript, it essentially says, I didn't see enough to tell you. Mr. Woods tells the officers that he saw the man with the rifle for less than 10 seconds. That's volume 3 at 118. And then we're told that later Mr. Woods identifies Mr. Spears from a photo lineup. That's volume 2 at 83. Except that's not the whole story. Because at trial, the facts are eventually developed that what happens is after the initial conversation with law enforcement where Mr. Woods tells them, I only saw him for less than 10 seconds, Mr. Woods then, in his words, sets about getting more information and communicates with some unknown people and does some research on social media and eventually provides the investigator with the name Amir Spears, having found him on social media. The investigator then has him do a lineup, which I will suggest is of limited utility given that he has already said, I found his picture and this is the man I want to report to you. So I then identify him from the lineup having already seen the photos from social media. When he looks at the lineup, he identifies him as, that's Mr. Spears. So the actual story, the story that the government knew, was that following the event, there was some secondhand information provided, there were some conversations had, he looked at some photos, he did some research on social media, and he came up with the name of Amir Spears. But the information that the defense has, the story that the defense has, is the victim picked your guy out of a lineup. And so it's not until trial that we have what trial counsel described in volume 9 at page 59, what trial counsel described as, quote, a surprising development in the middle of trial occurs. So our position is that that is a Brady-Johnson issue, the Brady being the federal side and Johnson being the state side, that is an issue that must have, that the circumstances of that, the circumstances that this individual initially reported a very brief interaction, did not provide a name, and then at some point later told a story of going through, doing some research, talking to some people we still don't know who, getting additional information, and then reporting a name to law enforcement. That story, that detail, is Brady-Johnson information that should have been produced. And the reason for that is...
So, Mr. Hedrick, let me ask this, and let me see if I can tease it out just a little
Sure.
bit. So Brady applies to information that is exculpatory, meaning showing that perhaps the defendant didn't commit the crime, or perhaps even that no crime was committed. It also applies to information that is favorable to the defense. And
Correct.
that may be something that is less than exculpatory, but may have some other value,
Correct.
impeachment value, for example. The information here is not obviously exculpatory, it's an impeachment issue. Would you agree with that?
I somewhat agree.
It impeaches
I
the
agree that it is.
identification.
I agree it is impeachment, but I suggest it goes further because it is information that leads to potentially fruitful defense investigation and potentially fruitful
Sure.
defense work.
Favorable to the
Not
defense,
more than
not
just
obviously exculpatory, though.
I wouldn't say that it is exculpatory, but it is It is Brady. It is likely to lead to fruitful defense investigation. It could be used to impeach or challenge the identification.
Sure.
It would have led, we know from the motion for new trial hearing, it would have led defense counsel to have engaged an eyewitness expert.
Okay.
And
Was the information, so the first thing that Brady typically requires in a case where it's not obviously exculpatory is that a request for the information was made. Was there a request for this type of information?
that's where the record lets me down a bit, Your Honor. And the reason I say that is there's a footnote in the brief, I think, to this effect. The record does not contain a discovery demand. However, there is a pleading relating to, I think, a motion to continue in which defense counsel recites having received voluminous discovery. So there was discovery produced, but the discovery request does not appear to have been filed with the court.
Okay. Was there a request made? I mean, in some cases.
So I
know-
cannot, right,
Yeah.
that is a really awkward way for me to say no.
Okay.
That at least that I know of.
Okay.
That I know of, I cannot point to something in the record.
Well, then
and say-
how do we get to the rest of Brady then? So if we're agreed that this is not obviously exculpatory, but it's favorable to the defense, but
Mhm.
the very first prong of Brady requires that a request is made, how do we get to the rest of it? Seems to fail on the first prong.
So I think that we have to conclude that there must have been some sort of discovery demand made. My difficulty here is that in terms of this information, there would have been turned over the lineup and the materials surrounding the lineup because it appears through the record that defense counsel was in possession of that. And so if there was a request, if the lineup was turned over, whatever request caused that to be turned over should have also triggered the Brady obligation relating to the lineup. That is, if you're turning over the lineup, it is necessary to also turn over the attendant circumstances when they are of this type.
Or is it the difference between that and I'd like to have the prior statements of witnesses, Jenks Act materials, for example? I mean, that's really what this is, right? I mean, the allegedly favorable evidence is actually just a statement of a witness,
So
not necessarily something intertwined with the lineup itself.
it rides the line.
Sure.
I don't disagree with you. It certainly would be covered by Jenks. But it is of the character, it's almost like a legally operative fact. And when we think about hearsay and statements, it's almost more than a statement. It's almost a circumstance. It is a statement, but it describes a particular unique circumstance that changes the way we view the lineup. It's almost like I would analogize it to picking someone out of a lineup and then saying, I'm about 40% sure this is the man, right? That would be a Jinx Act statement, but I think that it would be incumbent on the government to include that in providing the lineup, that it is misleading to provide the lineup without saying, he said he was only about 40% sure, or 20%, make it really extreme, 20%
So at the hospital,
sure.
did Mr. Woods say, I don't know who shot me, or did Mr. Woods say, I don't know the name of the person that shot me?
As I understand it, he was not able to give any identifying information.
Okay.
I don't think he gave any kind of description. I don't think he gave any kind of information other than I was shot, and I'd only got to look at him from. I can't say that I know exactly what he said at the hospital.
But that sounds like that was an early Jinx statement that was provided to the defense, that he was at least unable to do it at that time. And I'm trying to figure out, you know, after reading through all of this, it's a little unclear to me, and I want to get your perspective on it. How well is the record developed in terms of what actually happened? Did he conduct an investigation and he received this name? He found that name on social media and he said to himself, yes, I recognize him. That's the guy that shot me. Or on the other hand, was he given the name? He said, I found this guy on social media. Give me the lineup. Yeah, that's the guy I found on social media. How well was it developed in those terms?
So, I think it is relatively, I think it's as clear as can be. In the record at 466, we have testimony from the investigator who explains that he had seen, he had had more than one interview with this fellow, and that at one time he gave Mr. Bowman's name more accurately. That's at page 466. And then at 467, he says that he didn't really. Sorry, just a second. He says that.
Well, at 465.
It's 46. Sorry, excuse me. It's 466 that
Sure,
we're
but
talking
at
about.
465, the officer is talking about seeing Mr. Woods in the hospital. And says that he went to the hospital that night, obtained some information at that point. No suspect names were mentioned then for sure. Went the next day when they were released and spoke to him some more about other details. It sounds like, going back to Judge Hickson's question, it sounds like just from that offering of testimony that it was a suspect name that was at issue, not that Mr. Woods could not identify the accused.
So he says initially he mentioned a possible, and this is 466. Apparently, initially he mentioned a possible first name, but he wasn't sure. And then he had been getting some more information. I think he was getting some of this information on social media and so forth, just things he had been hearing, what you might want to consider it secondhand going around, but names had been surfaced. And once those names started surfacing to Mr. Woods, that's just how I took it, was that he started, I think Mr. Woods, he started doing some research, pulling up pictures of anyone underneath those names, but he provided, whether it was the 29th or the 6th, I know he gave the name Amir Spears. So
there was a possible first name given. Was there any follow-up on that?
There was not a follow-up question. It sounds to me like these are multiple names being passed around. It sounds to me like.
Was Mr. Woods asked about it?
I'm sorry?
Was Mr. Woods asked about it?
No.
Not even on the motion for new trial?
He was not called as a witness at the motion for new trial.
We kind of need that, right? Don't we need to have what his actual recollection was and what happened with him and how he made the identification? So if it's not asked at trial, and this is a Brady issue, and we have to show that it's material information, isn't he an essential witness that should be called on the motion for new trial?
So at some point, ultimately the question really isn't whether he provided the name or not. The question is, what were the circumstances by which his identification may have been infected by post-event suggestion?
Right.
Right? So whether he offered the first name Amir or not is a factor to consider. But ultimately what we're talking about here is the defense counsel at the middle of trial realized that there was an issue with this eyewitness identification that should have been addressed by educating the jury about the impact that these post-event suggestions can have on someone.
Did Mr. Woods testify prior to the testimony of this officer, or did he testify following?
Testified prior to. Mr. Woods testified prior to this officer's testimony. Essentially, the officer, I think that Investigator Lee was called by the defense in an effort to figure out what's happening here. Because what happens is that at page 464, Mr. Trial Counsel calls Investigator Lee as a defense witness for the purpose of essentially asking, what happened? What are we talking about here? How was this identification made? Because it doesn't appear that there is a way for this identification to be made, given the very brief exposure, the lighting, the fact that Mr. Woods testifies he had never had any contact with him before at all, and all of a sudden he just has this name of someone he's never met.
Why were those facts not enough to suggest to the defense counsel, who is not you, as I understand, that maybe they should have retained an expert in this area of eyewitness testimony?
Well, that's the difficulty, and that's where there's sort of an interaction. My first two issues interplay with one another, and they're kind of tangled, honestly. But the difficulty that exists is, if defense counsel believes that this was a lineup, a pure lineup, without these other suggestive influences and without this other research, if it's just a lineup, then it's very difficult to justify the opinion of an eyewitness expert. It's a very different opinion, right? To say, I saw that man and then I saw him again in the lineup and I'm dead sure that's it, is a very different question than, I saw a man, I didn't really have a name for him and I've never seen him before, and then I talked to a bunch of people and I listened to some gossip and I poked around on Facebook, and after listening to gossip and poking around on Facebook, I think it's this guy. That is a very different scenario for an eyewitness expert to come in and say, okay guys, that's a problem.
On this record, though, how do we know that it's not the former scenario that you mentioned? How do we know that he's not definitively saying, yeah, that's the guy that shot me?
Because he was never asked.
Well, I think that you can conclude it from the testimony that's given, because what he doesn't say, when Investigator Lee describes for an entire page the process that he went through to get an identification, he doesn't say, he said, that's the guy. I know his name, I just need to look him up on Facebook and I'll show you a picture. He doesn't even give a name. Investigator Lee doesn't say, he told me it was Amir.
But we're assuming he was shot by a stranger.
Right.
So he wouldn't have his name.
Right.
If someone told him in the community, oh, Amir Spears hangs out with these guys who were identified.
Right.
He looks up Amir Spears on the internet and says, oh, yeah, that's him. I found him. Let me give that information over to the police.
That's the scenario where we're concerned, because that's the scenario where, and we can see from I see it that I'm over, I'll wrap it up quickly. That's the scenario that we see from the testimony of Dr. Nushatz, that's exactly the scenario that he would describe as suggestive. That it is suggestive to say, the guy you're looking for is this man, then you look him up and your mind tends to assume that that is the man. It has been suggested to you that this is the man, because the people that you're talking to are telling you, that's Amir. Amir does that kind of stuff.
But the expert also didn't speak with Mr. Woods, right?
I'm
sorry, the expert also didn't speak with Mr. Woods either. It looks like no one has asked the one person that we should ask about these questions. So trial counsel didn't ask about it during cross-examination. He wasn't called on the motion for a
Right.
new trial, and the purported expert never spoke to the witness. And so
Right.
it seems like we're offering opinions without actually knowing what the actual facts may be from the witness's perspective.
I would tell you from my personal experience,
Sure.
and this is outside the record, that eyewitness experts are hesitant to, eyewitness experts don't like to say whether an identification is good or bad, because they don't want to get inside the mind of the person. So they would say, I don't need, what I do doesn't require me talking to Mr. Woods. I'm just here to educate you on the risk factors.
But you have to talk with Mr. Woods to know about what the facts of the identification
What the facts of the
were,
identification were.
Right, and
Right.
so, okay, all right, that's fair enough. Thank you, counsel.
Thank you.
Thank you. General?
Afternoon, Your Honors. May it please the court. Benjamin Barker on behalf of the state. Your Honors, this court should affirm the defendant's convictions because he has not established that the state violated its Brady obligations, because trial counsel performed effectively regarding this eyewitness identification and regarding the rifle, and then finally the evidence was sufficient. But because Mr. Hedrick only addressed his first two issues, the state will do likewise unless this court has questions. Basically, the defendant here and several of his buddies robbed DeAndre Woods during a drug deal. In the process, they shot Mr. Woods and one of his friends who was there, who named Rashid, and shot and killed one of Mr. Woods' relatives, Denise Stevens. The defendant was convicted of first-degree felony murder, criminally negligent homicide, 2 counts of especially aggravated robbery, and aggravated assault. Now, Judge Greenholz, I think you rightly picked up on that defendant does not meet the first Brady prong. But I don't even think we get there, because ultimately this is not a non-disclosure case. This is just a delayed disclosure case.
Well,
As
but
Mr.
Brady, though, requires that the information be disclosed enough time before trial so that the defendant can make use of it. What I'm understanding here is that the information didn't come to light until the defense case.
That's correct,
So
Your
because
Honor.
it didn't come to light until the defense case, the defendant didn't have the opportunity to go out, as I understand the argument, to find an expert to be able to present that. So even in a delayed disclosure case, I'm afraid your disclosure may be too late. So I think we do get back to the first prong.
Well, very well, Your Honor.
Sure.
Either way, it's the state's position
Okay.
that he just cannot establish all 4 of the Brady prongs. You're right that this came in during the defense proof. And really, the record is just murky as exactly how all of this shook out. I think at best what we have is that Investigator Lee believed that Mr. Woods found defendant, found his name on social media after the fact.
So your friend on the other side suggests that even if the record doesn't have the actual request that was made, that it's evident, self-evident perhaps, that a request was made that would have included this, simply by virtue of getting the information about the lineup, for example. What's the state's response?
That may indicate that there was a discovery request made, but that certainly doesn't show what was in the discovery request, much less that he requested this specific information. Requested, the circumstances of this identification.
Okay.
Ultimately, even if defendant meets the first 3 Brady prongs, he just cannot show that if the defendant, if counsel had known about this beforehand, he cannot show that it would have, a different result below would have come from it.
So does the state concede then the other prongs? One, that maybe not that a request was made, but 2, that it was suppressed or not disclosed until the defense case, and that 3, this actually is information that's favorable to the defense. The state concedes those 2 points?
I wouldn't go so far as to say that the state concedes those 2 points.
How do you challenge them then?
Well, it's like
So
you talked
it
about.
it is information favorable to the defense, right? Because it goes to the circumstances of the lineup and the identification, an essential element of the offense. So, I mean, do you have an argument that it's not favorable to the defense?
Well, perhaps it informs about the circumstances of the lineup that was conducted, but it certainly doesn't taint the lineup.
No, but it's impeachment of a witness, right?
Yes, Your Honor.
Okay, so it's favorable to the defense. we've already, I guess, talked about the delay. How is it not material?
Well, ultimately, because even if it's true that Mr. Woods learned the defendant's identity afterward, he still identified the defendant at trial as the rifleman, as did two of the defendant's cohorts, Mr. Davis and Mr. Jones. And so, trial counsel made these kind of conclusory statements at the motion for new trial hearing that had he known this earlier, it would have led to fruitful defense investigation, and he would have impeached with it. And he very well may have impeached with it, but
we know that's true, though, right? Because he called the expert on the motion for a new trial hearing.
that's correct.
So it's not
Your
just a conclusory statement. He actually offered what he thought was sufficient proof on the hearing for the motion for new trial.
Well, not Mr. Hedrick. Trial counsel stated at the motion for new trial hearing that it would have led to fruitful defense investigation without teasing that much out. Besides saying, "Oh yeah, I would have looked into Dr. Neuschatz." Ultimately, even if all of this is true, the defendant just has not established a reasonable probability that the outcome below would have been different. And I think that this is probably chiefly so because of the co-defendants' identifications. And even if Mr. Woods did not know the defendant's name beforehand, he certainly still saw him. And like you talked about earlier, this is not so much an issue of identification. It's just an issue as to what his name was. He just didn't know his name, but he did see him, and he identified him.
So the co-defendants are accomplices.
That's correct.
Their testimony was corroborated sufficiently at trial for the identification from their testimony to come in?
I believe so, Your Honor, because, again, we have Mr. Woods' identification. We don't just have the lineup. Obviously, I'd yield to the record, but as I recall, Mr. Woods identified the defendant at trial as the rifleman. And so that is absolutely sufficient corroboration to the co-defendants.
You're saying that Mr. Woods' identification is corroboration to the co-defendants. It seems like that's kind of a circular argument. What I understood you to say a moment ago was that Mr. Woods' identification was bolstered by the accomplice testimony. And what I hear you saying now is that the accomplice testimony is bolstered by Mr. Woods. And I think what your friend on the other side is doing is trying very hard to cast into doubt Mr. Woods' identification. And so if that falls, and we're without that in the record, then I'm asking, is there sufficient corroborative testimony such that the accomplice testimony could be considered by the jury?
I believe so, because ultimately, when this court is reviewing sufficiency, including identification, this court reviews sufficiency in light of all of the evidence that was admitted at trial, even improperly admitted evidence.
Well, let's flip it around and look the other way then. How does it affect the prejudice analysis under Brady if you're looking at Mr. Wood's testimony as being the only thing that is allowing for the sufficiency of these accomplice testimony? If he's the only piece of corroborating evidence and it is you have questionable circumstances perhaps about how his eyewitness identification occurred, how does that affect the Brady analysis?
I don't believe it does, Your Honor, because again, the defendant has to show a reasonable probability that the result below would have been different. And he just, even in light of Dr. Neuschat's testimony at the motion for new trial hearing, he just cannot negate this identification. He just has not. He hasn't built up the record enough to really show what the circumstances of the identification really were, just what the investigator's perception of the circumstances of the identification were. Does that make sense, Your Honor? If this court has no further questions on that issue, I'll move now to the effectiveness of trial counsel on the eyewitness expert. Dr. Neuschatz testified kind of generally at the motion for new trial hearing about eyewitness testimony and perhaps some pitfalls associated with it. But Dr. Neuschatz could not specifically say that Mr. Woods' identification of the defendant was unreliable. In other words, we just can't get past the point, this might have helped. And this court has said, as cited in the state's brief, that just giving the jury more information without specifically negating this identification is just not enough to come over the Strickland hump there. And so ultimately, the defendant cannot establish prejudice under Strickland for that reason alone.
And maybe you can help me with this, maybe General. As I read the ineffective assistance of counsel argument related to the eyewitness identification, I thought that, or the post-conviction remedy, I thought it was related only to Brady, not to ineffective assistance of counsel. And the reason I thought that was because I thought at the motion for new trial hearing, counsel said we're not raising essentially the failure to object to the identification as being ineffective. I'm raising it as a Brady issue. So, I mean, we're talking about ineffective assistance, but it looked to me like it was restricted to Brady.
That very well may be, Your Honor. I'd cede to the record on whatever the record says there. I was trying to be responsive to Mr. Hedrick's arguments that he's raised on appeal.
Does the state have a position about whether issue number 2 is limited to Brady, or does it encompass ineffective assistance of counsel claims also?
If the defendant abandoned any ineffective assistance claim as to the eyewitness expert below, I'd say that he can't assert it on appeal.
I
Certainly.
agree, but do you have a position on that, though, without me referencing the record? I mean, do you have a position on what the actual issue is?
Whether it was effective assistance or a Brady claim,
Right.
I don't believe that the state has a position as I stand here right now, Your
Okay,
Honor.
fair enough.
Again, I was trying to respond to the arguments that Mr. Hedrick made.
Fair enough, okay.
I see that I still have ample time left and I've only addressed the 2 issues that Mr. Hedrick had time to address. If this court would like me to address the 2 further issues, I'm happy to. Otherwise, I'll cede the remainder of my time and ask that this court affirm.
Was defense counsel, or trial counsel, I should say, deficient for not asking for a continuance or a mistrial when this came to light?
I don't believe so, Your Honor, because ultimately asking for a continuance or a mistrial was not the only arrow in trial counsel's quiver. Like he did. He called the investigator during the defense proof to try and tease this out a little bit more. And very well, they could have recalled Mr. Woods to try and figure out what exactly happened here.
So the state is conceding that the failure to ask for a continuance is of no moment?
I believe that's correct.
Okay.
Trial counsel was not deficient for failing to ask for a continuance because there were other reasonable alternatives that he explored. And trial counsel even mentioned the circumstances of this social media investigation during his closing. So if this court has no other questions, all right, we ask that you affirm. Thank you, Your Honors.
I don't know if I have any rebuttal time left,
We'll give you your rebuttal time.
but
Anytime I'm sitting with
maybe
Judge
if I just
Greenholtz, I'm
keep
gonna give you your rebuttal time. That's, when we were talking earlier about knowing judges, that's generally something I'm gonna allow, so go ahead.
it's kind of you, Your Honor.
It
Across
is.
the
Yes, it
street,
is.
they're not quite
Well,
as
It's better for everybody. so.
Well, I'll say thank you.
Yeah.
So ultimately, what I want to point the court to volume 9 at page 22, where Dr. Neuschatz explains that in his professional opinion, it is not possible to separate what Mr. Woods remembers from the event from what he remembers from social media. That the way the human mind and memory works is that those become conflated with one another in a way that they cannot then be separated out again.
But we don't know that still, do we, from this record?
Well, we know that is true from, in terms of the study of the way the mind works, that it's not possible to separate the post, that's the risk, that's a problem with post-event
But we don't,
suggestion.
I guess what I'm getting back to is the problem that's been acknowledged. We don't really know how the exact identification rolled out.
And that's what the jury should have been told that. The jury was entitled to know that, right? And it was the government's obligation to demonstrate that this was a good identification, right? If there had been a motion to suppress the eyewitness identification, that would have been that's what would have come from.
There's no state action here. Where's
Well,
the state action?
I don't mean from a constitutional, I mean maybe suppress, exclude.
Okay.
Exclude the identification. You're right. It is not a motion to suppress. It's to exclude the prior identification. And to tell the jury, under these circumstances, there's no way to know if he's identifying the right person, because the two co-defendants, one of them has previously admitted that the first version of the story he told was an entire lie. He has admitted to be a liar. And this trial was held during the lifetime of our now departed accomplice corroboration rule. So this is a difficult position to be in as a defense attorney. And the reality is that it wasn't disclosed. The only reason it came up was defense counsel was wise enough to put the investigator on the stand and go fishing. And respectfully, that is not the appropriate way for this type of information to come to the defendant, is because defense counsel was brave enough to fish at trial. It should have been provided in advance of trial so that he could have had a fair trial. And because it wasn't, the conviction should be reversed. And I'm very over my time, and unfortunately, I've never even got to mention the rifle in the pants. So
We were looking forward to that too, but we've read it. in
I'll
the
have to
briefs,
rely on the
so-
briefs.
and the
Thank you, Your Honor.
pictures.
the
Thank
rifle
you.
in the briefs, Your Honor.
Yeah, yeah. All right, very well. That concludes our docket today, and the lawyers are going to stay around. Look out and see so many students here. We see you. We appreciate that you're taking the time to come and learn about the appellate courts and the Court of Criminal Appeals in particular. Thanks again to all the administration and all of our support staff here who have made this happen today. And we have thoroughly enjoyed it. We've all said this, that we enjoy this so much more than our regular arguments. And we enjoyed lunch with you and having your interesting questions and just getting to know you all. So
Yeah.
anything else you all want to add?
Just thank you all for allowing us to be here. You all have been our hosts. You've been gracious and consummate hosts. Thank you for the interest that you've shown, and just thank you for your hospitality. It's been wonderful to be here and spend some time with you all today.
It's been great. Thank you, guys. Thanks for all
Thank
the
you.
fish.